Well, good afternoon, everybody. Hey, this is Bill O'Leary, and I'm going to be talking about a probate today. By the way, for those that maybe are seeing me for the first time, I go live every Thursday at about this time, and I talk about a different topic that I deal with in what I do for a living. So I'm an attorney focusing on estate planning, elder law, and probate, and my firm is a Legacy Planning Law Group. We're in Jacksonville, Florida. So, if you're thirsting for knowledge and for information and guidance, you have come to the right place. So, today I want to talk about three questions that we get a lot that deal with probate, three common probate questions. So, first, just a little overview. So, when someone passes away, well, they typically leave behind assets and maybe property, possessions, tangible property that can have value for family members and loved ones, both monetary value and sentimental value. Everything that a person owns at their death is comprises their estate. And according to a website, estateexec.com, short for executor, estateexec.com, the average size of an estate is between $50,000 and $250,000. 11% of estates are under that $11,000 number, so very small. And about 11%, the same percentage, are above $1 million. So that gives you a sense as to the size of estates that are typically encountered. Some assets, by the way, depending on how you set them up, will transfer directly to heirs or beneficiaries after a person's death without having to go through a legal process we call probate. But other assets, in fact, many other assets, will have to go through the hot mess in Florida that we call the probate process. So probate, real quick, it's a legal process where a court is going to oversee the handling or the administration of the estate. The process itself involves sort of confirming or validating, if you will, the deceased person's will, if they have one, paying off the debts, the decedent's debts, creditors get paid first, and ultimately distributing assets to beneficiaries. If there's no will, heirs that are listed under the state law called the intestate or intestacy law will receive the estate. So the state will impose its plan and its list of beneficiaries. Now, assets that can be probated, that can include a wide variety of assets: real estate, financial accounts, investment accounts, bank accounts, and personal belongings. Typically, the estate representative is going to initiate that process. By the way, this person is called the personal representative. You may know this person to be the executor. That's a term many people have heard. If there's a will, it really should name someone to serve as the executor who's going to be responsible for distributing the assets. The sad reality is that not many people have a will. In fact, studies show that about a third, that's it, about a third of people have a will. So when someone dies without a will, who can initiate a probate? An interested party. Well, that could be maybe a spouse, maybe an adult child, another potential beneficiary, even a creditor, an unpaid creditor of the deceased person can initiate a probate. For those who have not dealt with the probate process before, it can be a very unfamiliar and mysterious process and daunting. So I want to talk about those three questions we commonly get about the probate process. The first, how long do you have to file a probate after death? And so how long or the length of time that an interested party or maybe an estate representative, let's say, has to open a probate, it depends on the state. It varies from state to state. Some states impose strict deadlines. The good news is that in Florida there is no deadline per se, but that said, it usually is a much better idea to get the process started as soon as possible, especially given probate can last for a long time. The second question we get, how long do you have to transfer property after death? After a property owner passes away, the ownership of that property, and let's talk about real estate, real property, it has to be transferred to another party or person. Well, in certain circumstances, a person's house may not have to go through probate, depending. Let's say if the property was owned as a joint with right of survivorship or tenants by the entirety, or it was your homestead, it may be able to skip the probate process. Also, if an asset is held in a living trust, it allows those assets to pass directly to beneficiaries outside of probate. Now, property that is owned individually or as what's called tenants in common, that property does become subject to probate. Once the property becomes part of the probate estate, the court is going to determine who receives the property. So again, the court gets involved, and the court's going to make that determination based on, one, if there's a will in place, and if it's a valid will, what the will says, or two, if there is no will, what the state says, who the beneficiaries all are under that intestacy law. By the way, the court may require a sale of the property to satisfy debts or distribute money to beneficiaries. Third question we asked has to do with discharge. What is a petition for discharge? That's the question. A petition for discharge is an essential kind of step, if you will, in the probate process that allows beneficiaries and heirs to obtain assets from a person who has passed away. The executor files the petition to request the court's approval to distribute the assets and ultimately close the estate. So this discharge petition, first of all, will specify how the beneficiaries will receive the assets. It also discloses how much money the executor is going to receive as an executor fee for their services, how much the attorney's fee is going to be. And after the court approves the request, the executor can distribute the assets to the beneficiaries. And at the point when a petition for discharge is granted, the executor is discharged of any potential further liability, let's say to beneficiaries or creditors. An executor wants that all important, what's called court order of discharge. If you'd like to know a little bit more about the probate process, and maybe you have some of these questions yourself and you'd like to find out how we can help, we'd love to talk to you. So we invite you to schedule a discovery call. That's a free 15-minute introductory call that we have. And scheduling is easy. Hey, just go to our website, Legacy Planning Law Group, and click on the book your free call button. You can't miss it on the homepage, and other pages as well has the same button on it. Is a chance to start the conversation. If you've liked this video, we would ask that you like the video if you've enjoyed it, if you liked it, and better yet, share it. And subscribe to our YouTube channel, Legacy Planning Law Group. We keep putting up more videos all the time. So, hey, before signing off, I'm going to give another talk next Thursday at about the same time, sort of mid to late afternoon, part of our Thirsty Thursday series. So if you're thirsting for knowledge, we will quench your thirst. So, Bill O'Leary, I want to sign off for now and encourage you to go make it a great day and a better world.